Welcome to this afternoon's Board of County Commissioners Land Use Meeting for Tuesday, September 14th, 2021. It is now approximately 2:45 in the afternoon. If you'll all rise and please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
That's related. We're having some technical issues. If you could just
Oh, sure, yep. It sounds like we're having some technical difficulties. We'll just stand by for a moment. So everyone, thank you for your patience. We're still having some technical difficulties, but for those in the audience, I'll repeat this on the record, but the expectation for items 3A and 3B is that those will be continued. And we have, it looks like a continuance for item 3A to October 12, 2021 at 2:30 p.m. and a continuance of item 3B to December 14th, 2021 at 2:30 p.m. Again, I'll repeat that for the record, but if anyone is here to speak to those items, just wanted to let you know that that is what is expected today. Thanks.
Enter the event panelist numeric password, followed by pound. This meeting is being recorded.
So apparently they don't have video. We have audio for Granicus. Is that sufficient if we have just audio?
Yeah, it's not ideal, but it's sufficient.
So we are recording in Granicus. It's the live feed is on the record. YouTube is also seeing video. It's just the attendees that can't see the room. I don't know if they'll be able to see the presentation.
So could they log on a different way?
So welcome back, everybody. I appreciate your patience with the technical difficulties. Unfortunately, it appears that some online will only be able to hear and perhaps not see the presentation unless they're able to see it through YouTube. I'm just a commissioner. I was told there'd be no IT that I'd have to do today. So what I might do is I'm going to have Sarah Knight from IT just come up to the podium and reference for citizens how they might be able to participate for today's purposes. Sarah?
Thank you, Commissioner, and my apologies for the technical difficulties. We are up and live on YouTube. We are also visible in our Granicus, which is the record that we use for the recording. For those that are participating through WebEx virtually, we cannot be seen, but we should be able to be heard. And if you wish to have any comments, you can either chat them to our host, Troy, and she can keep those for the record, or we can hear you over WebEx as well. Again, if you want to join on WebEx, if you have any feedback that you want to give to the commissioners, please join us on WebEx or send the chat to our host.
Okay, thank you, Sarah. It's a priority for this board to make sure that all of our meetings are very transparent and publicly accountable, so I appreciate the hard work of our IT staff to make sure that that occurs. So with that, we'll just resume where we left off prior to the IT challenges, and we'll just repeat for the record or bring up Attorney Ingalls. Do we have certification for the agenda?
Yes, Mr. Chair, you have 3 items on today's agenda. Item 2A is labeled as a road vacation. In fact, it's a replat. A replat does not require any specialized notice, but it is properly noticed for today's hearing. Item 3A was continued from August 10th until today. And item 3B had published notice, posted notice, and mailed notice on August 5th, August 6th, and August 3rd, respectively. With that, you have proper notice and jurisdiction on all 3 items on your agenda.
Thank you, Attorney Ingalls, for that certification. Do any commissioners have any disclosures for any items on this agenda?
I have none, thank you.
No, sir.
And I have none either. What I might ask today, since we have 2 items under 3A and 3B that are being continued, if it would please the board to rearrange our agenda for today to bring up item 3 to item 2 so that we can go ahead and continue those particular items, and then we'll go into our land use meeting items with Perry Park filing 1.
I concur.
I'm fine with that.
Okay, so with that, we'll begin with item 3A, which is Sterling Ranch Plan Development Amendment to Water Appeal, Project File M1 2021-004. Brett Thomas presenting for staff.
Good afternoon, Commissioners. Brett Thomas for Planning. The application MI 2021-004. The applicant requests a continuance of the hearing of this application to October 12th, 2021 at 2:30 p.m.
Okay, thank you very much. Any questions or comments for Brett?
I have none.
No questions.
And I have none either. Would the applicant want to come up, or shall we just move forward with a motion to continue? Okay, I see Commissioner Beckman saying no thanks in the back. So we will move forward with any public comment on this particular item. Is there any public comment on this item 3A in the room? Troy, is there any comment online?
Thank you, Commissioner. I have no online comment.
Okay, and with that, I will close public comment and bring it back to the board for any further discussion and or a motion.
Mr. Chair, if it pleases the board, I'd like to make a motion to approve the request for continuance of the amendment to the water appeal for the Sterling Ranch Plan Development Project File. Oh, I'm going to need my glasses for this one. MI 2021-004 to October 12th, 2021 at 2:30 p.m.
Second.
There's a first and second. Is there any further discussion on the motion? Seeing none, all those in favor signal by saying aye.
Aye.
Aye, and that motion carries. With that, we will move to item 3B, which is Range Planned Development Rezoning Project File ZR 2020-023. Matthew Jacobowski presenting for staff.
Good afternoon, Commissioners. Matt Jacobowski with Planning Services. The application ZR 2020-023 Range Plan Development has requested to continue to the December 14th, 2021 Board of County Commissioners hearing. The applicant provided a written request that I received yesterday afternoon that I can enter into the record. I also understand the applicant is here and would like to provide some background on the request for the continuance.
Okay, thank you, Matthew. Any questions or comments for staff at this time?
I have none.
No, sir.
And I have none either. And with that, we'll call up Commissioner Rapella. Commissioners are lifetime titles, so I like to call you and Commissioner Beckman Commissioner. It's a big, you did a lot of service for this county, so welcome. And if you can just state your name and address for the record.
Thank you, Commissioners. Jill Rapella, last name Repella, address 10129 Summit View Point, Highland Ranch, Colorado. Thank you. The first thing I would like to do is I'd like to thank staff for all the effort and work that I have engaged with them over the last year and a half on our application. They were excellent to work with, very thorough, very diligent, and very respectful, and I just want to express the appreciation for those efforts, Matt Jacobowski specifically. So with that, we are requesting a continuance. It's curious that we are here requesting the continuance because of a letter that we received 4 days ago on the heels of a unanimous support by the Planning Commission. We received a letter from Dominion Water and Sanitation, which in all the years that I've dealt with land use on the Planning Commission as well as the Board of County Commissioners, I've never seen a water provider intervene during a zoning hearing application. I have some records that I would like to provide to the board to put some information that was included in that Dominion letter into context. The first document I would like to provide is the Dominion's Developer Deposit Agreement. This was the very beginning of the effort in our process with Dominion. This was over a year ago. This is the agreement to move forward and evaluate serving our community, the range project, which is in the service area. Sept, I may.
And Commissioners, for the record, this will be labeled Exhibit 2. That's because the actual request for the continuance is labeled Exhibit 1 for today's hearing.
And I provided 4 copies in that document. I'm not going to go over it. I think it's self-explanatory. I did highlight some important aspects within that document for your review. The second document I would like to provide is the contract that we negotiated with Dominion that was completed a couple months ago after a significant amount of time and effort with staff, with engineers, and with attorneys. We had finalized a contract with them. The reason this document is important, it highlights some of the items that were submitted in the letter last week. I want to provide the facts of what we did agree to, which is inconsistent with what the letter stated. Again, I've highlighted and noted these things within the contract that we've agreed to sign with them. It did not get executed, and it did not need to be executed until subdivision. Okay. So again, I'm not going to go in detail with it. I think it's self-explanatory.
You may approach.
It'll be Exhibit 3.
Again, there are 4 copies included in that. With that, I want to express that we are still continued to commit to working with Levere's and helping them with their water problems. It's apparent that Dominion no longer intends to work with us and serve our project. With that, we need to seek a continuance to move forward on an alternative water plan for our project range. But I wanted to make sure that you had these documents so you can see the full loop and the full circle of all of our interactions and negotiations with Dominion.
Thank you, Commissioner. I have a copy of Exhibit 2. Mr. Ingles, was there an Exhibit 1?
Exhibit 1 was the email request for the
Just the email.
continuance. I
Okay.
provided it to you right before we started. Sorry, I didn't relabel yours.
Okay. Would the board like to take a moment to review this, or does the board have any questions or comments for the applicant or staff?
I don't have any questions.
No questions. I'll review.
Okay. I don't have any questions either. Thank you, Commissioner Rapella, for coming before us today and sharing those important insights. With that, I will open it up for any public comment. Is there any public comment on today's action under item 3B? Seeing none in the room. Troy, do we have anybody online that wants to comment?
Thank you, Commissioner. I have no hands raised.
Okay, thank you, Troy. With that, I will close public comment and bring it back to the board for further discussion and/or a motion.
Mr. Chair, I have a motion to approve the request of a continuance of the Range Plan Development Rezoning Project File ZR 2020-023 until December 14th, 2021 at 2:30 p.m.
Second.
There's a first and second. Is there any further discussion on the motion? Seeing none, all those in favor signal by saying aye.
Aye.
Aye, and that motion carries. Thank you very much. So with that, we will move back up to our item 2A on the agenda, which is Perry Park Filing 1, 13th Amendment, Road Vacation LU, Project File SB 2020-062. Jeanette Baer for staff.
Good afternoon, Commissioners. Jeanette Baer representing Planning Services. The project before you is a replat request, project file number SB 2021-062. The applicants, the St. Clairs, are the owners of Lot 13 in Perry Park filing number 1. The county is the owner of the U Court right-of-way. Kevin Archer of David E. Archer and Associates is the project representative. The owners of Lot 13 request approval of a replat to combine their single-family residential lot with the undeveloped 50-foot wide Ute Court public right-of-way. The vacated right-of-way would be used to construct a private driveway to serve a future residence on that lot. The driveway would be 16 feet in width, and at this point in time, the applicant has indicated that they would like to install a gate approximately 250 feet from the entrance of Perry Park Boulevard. Per section 704B of the Douglas County Subdivision Resolution, roads that are established by plat but have not been used as such may be vacated and or replatted through a replat process, and any such road need not comply with the additional requirements of this section 7B, which is the vacation section of the subdivision resolution. In this case, U Court has not been developed or used as a public road. As such, it cannot provide access to Lot 13 unless improved and accepted as a county road, or as being proposed here, being vacated and being constructed as a private drive. Article 7 of the subdivision resolution states that the intent of the replat is to provide a review process for the replatting of an existing subdivision plat or superblock final plat. In this case, Lot 13 will be replatted to be combined with the vacated U Court right-of-way, resulting in an amended Lot 13A. The replat process begins with the submittal of an application, following a review period by referral agencies and the public. There is a public meeting held before the Board of County Commissioners. 2 neighbor comments were received on this application. Both neighbors abut the U Court right-of-way. One neighbor expressed support for the application on the basis that a driveway, as opposed to a public road, would be less disruptive to the natural environment and would eliminate recreational and other types of vehicle trespass on the unimproved road. Another neighbor opposed the application based on the desire to own or use a portion of the right-of-way for parking, wildfire mitigation access, and possible lot access if a lot division was requested by them in the future. All those comments are included in the staff report along with the applicant's response, and I know both of those neighbors are here today and will be speaking. Other referral agency comments have been resolved as noted in the staff report. Perry Park Filing 1 was originally platted in 1968. At that time, the county did not have subdivision controls in place to require the completion of roads and infrastructure before lots could be sold. U Court was never built, and abutting lot owners abutting lots have been developed utilizing other public and private access alternatives. Lot 13 is currently vacant and has no alternative public or private access besides U Court. This map shows the lot and right-of-way located in the Perry Park community. You can see it outlined there in red. Northwest of the intersection of Perry Park Boulevard and Red Rocks Drive. All the lots within Perry Park are zoned for suburban residential use. This slide shows an aerial view of the property in context with some of the surrounding homes. You can see here's the right-of-way, which would be combined with the lot. The owner of Lot 12 that is objecting to the right-of-way vacation replat is here, and then the other neighbor expressing support is over on this side. This slide shows the replat exhibit. Ute Court itself is approximately 0.69 acres in area, and when combined with Lot 13 would result in a single-family residential lot of 6.19 acres. So it looks a lot like a flag lot, is what it would look like. Other lots within filing one range from 2 to 6 acres in size. Typically, there have been some subsequent replats that have established some lots that are closer to an acre in size. Lot 13 and the surrounding lots have access to central water through Perry Park Water and Sanitation District. The district does allow the use of individual septic systems on these pre-existing lots. Splitting of lots generally will require connection to central sewer. A general purpose utility easement is being dedicated to the county over the former right-of-way with this plat. And then the applicant will provide an easement to the Perry Park Water and Sanitation District for a water line and other district infrastructure as requested by that entity. That easement agreement has been approved by the Perry Park Water and Sanitation District, and per proposed condition number 1, that agreement will be fully executed and recorded prior to recordation of the plat. Here's some site photos. This is a view looking south from the entrance of the right-of-way along Perry Park Boulevard. This is looking the opposite direction, looking more northward from that entrance. This is looking up the right-of-way. As you can see, there has historically been some grading of this, and there are a lot of vehicles that trespass up this kind of two-track. But there is no county road located within here. But you can get a feel for where the driveway location would be. It would follow generally this alignment and would likely be able to preserve most of the existing grade in the trees. This shows some of the condition of the road and some of the grades along the right-of-way there. This is one of the closest homes to the right-of-way. You can kind of see it off in this area. It's on the north side of the Ute Court right-of-way. If the driveway is built along that existing graded path, vegetation and grades, as seen from this home, would remain unchanged for the most part. Some of the other homes that are adjacent to the Ute Court right-of-way are set further back and are generally obstructed. Views are obstructed due to a lot of trees on those lots. This is looking at the end of the right-of-way near where the platted turnaround is. The driveway will include a turnout as requested by the fire district. A large cul-de-sac bulb would not be required for the private driveway. And finally, this is looking back towards Perry Park Boulevard. And again, as I mentioned, the construction of the driveway would allow for something 16 feet in width. If a public road or even a private road were to be constructed, it would require approximately 30 feet of improvements. Engineering can talk about that a little bit more. Also, with recent changes to our regs, I guess it hasn't been so recent, 3 homes can be served off of a driveway. A replat may be approved upon the finding of the Board of County Commissioners that these approval standards have been met. These were discussed in detail in the staff report. Should the board find that the approval standards for the replat are met, the following proposed conditions should be considered for inclusion in the motion. Number 1, prior to recordation of the replat, the applicant shall execute and record the access, drainage, and utility easement for Perry Park Water and Sanitation District. 2, prior to recordation of the replat, technical corrections to the plat exhibit shall be made to the satisfaction of Douglas County. 3, all commitments and promises made by the applicant or the applicant's representative during the public meeting and or agreed to in writing and included in the public record have been relied upon by the Board of County Commissioners in approving the application. Therefore, such approval is conditioned upon the applicant's full satisfaction of all such commitments and promises. This next slide shows a possible new 4th condition of approval based on the applicant's PowerPoint and some of the commitments they're making on the record. We suggested that this would be a possible way to handle that commitment by actually getting it added to the plat. So prior to recordation of the replat, a note shall be added to the replat exhibit that provides access over the former right-of-way to the owners of Perry Park Falling 1 Lot 12 to allow for parking near the driveway entry during times of inclement weather and for periodic landscape maintenance activities, except that such access activities may not obstruct the subdivider's vehicular use of the driveway. So that is just there for your consideration. The applicant has agreed to that. This slide sets forth the parameters for the board's determination on replat requests. So kind of your options for what can be done today. That concludes my presentation. Al Peterson is also here with engineering to answer any questions you might have of him regarding roads and driveways and such. I can take questions at this time. David St. Clair does have a PowerPoint presentation, and the applicant's representative, Kevin Archer, is also here to answer any technical or engineering questions you might have.
Thank you, Jeanette, for that presentation. Any questions for Jeanette or Mr. Peterson?
I have none right now.
I do have a number, Chair. So Jeanette, thanks for the presentation. If we go back in the slides, however, and we go to one of the pictures that actually shows the right-of-way, and if we could do that.
We can, I believe. Previous. Nope, I'm going the wrong way. Can you maybe take this off the screen for a minute so that people aren't looking at me messing around here? Any particular slide, Commissioner?
Any one of the, perhaps the picture that shows the entrance of the right-of-way from the Hardball Road?
Okay, you can bring it back up. Something like this?
Yeah, thank you. So I hope this isn't like a stupid question, but I've lived in Colorado since the 1980s, and I've lived in Douglas County for 20 years. That kind of looks like a road. Well, I guess I need to understand, what is the importance here to do this vacation and to do this replat? Because that looks like a road to me.
It looks like a road, but it really has not been improved to any standards, either a driveway standard or a public road or private road standard. So when Mr. St. Clair came in and talked to the county, he was told that there is not a road here. There was some grading done in the past. There's kind of a two-track, but it is not a road. And he would not be able to construct a home unless he actually built the road, the public road, had it submitted construction plans, had it accepted by engineering, or actually did away with the right-of-way and then would have the permission to do a private drive. So there's a traveled surface, but it is not a road.
What would it take for the county to do the additional work to make that a road?
Al, do you want to address that?
Al Peterson for engineering staff. The minimum road section that could fit in here in the inside county right-of-way would be a rural type 3, which would include 20 feet of pavement, 2 to 3 foot gravel shoulders, and roadside ditches.
We have a program here at the county where we will pave roads at the request of residents, which I have to, I'm sorry, I can't believe I'm asking a common sense question here, but if we have a paving program to pave existing county roads, I guess I just need to have it explained to me, why would we need to do the upgrade to a paved road in order to have this used as a road to enable construction by a property owner?
Matt, you want to help me out? Because it's in county right-of-way, it needs to be built to a county standard. That's the end of your last question. You want to address the county?
Matt Williams with engineering. The county assisted paving program, which is what I think you're referring to, Commissioner, that assumes that county road has been owned and maintained by the county for a certain amount of time, that it's been accepted, it's being maintained by the county as a gravel road. And then we have residents that take access off that road that are requesting that the county pave that road. This is not that case. We have not accepted this road in its current configuration. It doesn't meet any standard of ours. And so this would not fall under the county assisted paving program as it's currently written.
Okay, so as a part of the planning, the design, as a part of the development of this area, but the county never actually accepted it as an actual portion of the road network.
That's correct. And there are numerous examples, mostly in Perry Park. There's a good amount of roadways out there, or roughed-in roadways similar to this, that were never accepted by the county. They're in county-owned right-of-way, but they never were built to any standard that the county accepted.
Okay. I think that answers that question that I was going for, because I don't know. That looks like a road. Of the 30, 40 some years I've lived in Colorado, I've driven on roads like that. That looks like a road. Who did the prior grading? Because we heard in the presentation that grading had occurred in the past.
Yeah, that would, couldn't tell you. It could be just roughed in, it could be driven over, and maybe no grading took place. It's just kind of devegetated in the configuration that it was, back when it was natural ground. So it could very easily have just, been devegetated by people driving on it. But there could have been grading. The county obviously is aware of most of the grading operations in the county, but not all of them. So an owner out here, maybe an ATV enthusiast, who knows, could have gone out here and graded this without our knowledge.
What's preventing us from establishing it as a gravel road and accepting it into Douglas County road network?
It is something that we could consider. Generally, when we have a subdivision that has paved roads in it. We don't like to have offshoots of gravel roads out there. It takes different equipment to maintain those gravel roads. So engineering stance on this has always been that, you know, if we have a subdivision that has a main paved spine road in it, that we want that entire subdivision to be paved. We do allow for roadways that carry less than 100 vehicles per day to be built as a gravel standard, and we will accept that. So that would certainly fit this case here, if not for the fact that the road they're accessing is paved and the majority of the accepted roadways out in Perry Park are paved. So it takes a different equipment to maintain those, and I think that's, you know, that's kind of the stance that we've had with these, but it's certainly something we could consider here.
Okay. I think that concludes my questions.
Thank you, Commissioner Teal. I thought you were talked out earlier. I'm glad you were able to go through that line of questioning. Are there any further questions for staff?
I have none.
Okay, I have none either. And with that, we will open it up for the applicant's presentation. Welcome. If you could just state your name and address for the record.
Julie St. Clair, 6956 Fox Circle, Larkspur, Colorado, in Perry Park.
You should be able to narrow it down.
We're the same resident.
Okay, thank you. David St. Clair, also the same address, 6956 Fox Circle, Larkspur.
Okay, great. Please proceed.
Okay, thank you. Appreciate the opportunity to be here to present. There we go. Too far. What we wanted to do was start with a little bit of a timeline of what has been a bit of a journey for us. That started back in June of 2020 in a call with Sean Owens, who's project manager, or at least was at the time special project manager, I believe, for county roads and local improvement districts. Sean had helped us in the past to avoid purchase of a lot that would not have been developable for about 30 years. So he'd become a great resource to check ideas of future properties as we were looking to find a spot to build a home. He gave us a tip about this particular property, let us know about the issue with the road. As he explained it to me at the time, he said the county would never improve this because all the other abutting lots had been developed and had taken access elsewhere in Perry Park and not off of Ute Court. So we moved forward, we looked at the lot, we liked it. We started very quickly to look at the other obstacles to make sure that we had the ability to get into the land with utilities, with a fire district. And then we moved forward with a pre-submittal application, got the pre-submittal summary in June. It was very favorable. It suggested to move forward with this right-of-way vacation request. We closed on the property at the end of July. In August, we started to contact neighbors to let them know about what our plan was with the right-of-way vacation. There are 4 other properties that abut Ute Court. I was able to contact and speak with 3 of them. I spoke with John DeLay. I spoke with Carolyn Jones, and I spoke with Jennifer Crouch, who was the 3rd. The 4th I could not reach. I left a voicemail. So I spoke with all 3 of them in the middle of August of last year. There were no objections. Nobody had any issues with the plan as we explained it. So we moved forward with Archer, with Mike originally, and with Kevin now on a right-of-way vacation application. That was submitted to the county in October. The final referral period ended in March. There was an objection from Perry Park Water, which we've since resolved. That took a couple of months. That was resolved in June of this year. And then a couple of days later, we were informed by the county of the objection from the Delays, who own the other abutting lot that has been described and shown by Jeanette. So I reached out first to John, who referred me to Janie, spoke with Janie a couple of days after that, talked about that we could find a solution to allay their concerns. And we eventually met with Kevin Archer at the property, and we discussed and we left with an initial verbal agreement. So a couple of days later, we had the first email indicating agreement provided we have a written legal description of the agreement. That was followed again in July. So here we are now at a meeting with you. We don't have an agreement. We had a lengthy period where there was no response at all, unfortunately, from the delays, and we have not been able to make progress. We found in late August through phone call to our attorney, who we hired strictly to do the easement agreement, that they would not agree to move forward. So that's in a nutshell what's transpired since this process started for us. Some more pictures. The entrance to U Court, looking at the Delays property. Again, a picture of U Court itself. Here as we get around the curve, you can see a lot of the erosion that's taken place over the years, because there's quite a watershed coming down actually through our property and then onto U Court. Continuing towards the back, we're looking at the cul-de-sac here. And the area that's cleared in the back is the build site that we've cleared. We've done a lot of fire mitigation in the property, tree removal as well. This is showing it a little bit closer up. Here's an aerial view from the top, looking at the cul-de-sac area that was originally envisioned for U Court. You can see that it's quite rocky, it's quite steep, left and right, as you look left towards the Delay house, and as you look right towards a neighbor who's up on the ridge. Another picture looking back into the property, and then here's one that shows in yellow the boundaries of the property. Sorry, pre-fire mitigation, yes, absolutely. It'd be much more clear in the front portion of the triangle. So at this point, we're here to ask you to move forward and vacate U Course to enable us to move to build our house. It's been 13 months since we first had I first had a discussion with John about the right-of-way vacation delay, or excuse me, right-of-way vacation. We were quite surprised that many months later in June of this year to hear that they objected and they had not ever heard of this topic before, even though we had discussed it. We've tried hard to reach an agreement. We worked for more than 3 months on this, but ultimately there was some disengagement from the Delays, and with no dialogue, it's really not possible to reach an agreement. We also moved forward on our own risk with an agreement, hiring an attorney to draft an agreement to share with the Delays, which we did. And conversely, when we received guidance from the county after the objection, they said if you're going to have somebody who participates in an easement agreement, it's perfectly normal and accepted to ask them to participate in the costs associated with improvement and maintenance. We didn't do that. We saw no reason to do that. We accepted that it would be our responsibility. So we are the only property that's not built yet on Ute. We have the only one that requires Ute in order to reach it. There's no other way to access the property. And we know that the Delays have the ability to divide the property. Our perspective, looking at the steepness of the property, is that buildable areas can be accessed from either their existing driveway or from Perry Park Boulevard. So we don't see as much of a need for access to Ute as we do in order to be able to access our property at all. But ultimately, we're here without an agreement, but we would move forward, and we propose to just provide them with the permission that we had talked about originally, so that they could park at the entrance during the inclement weather, and that they would have access as needed, with notification to us for fire mitigation, tree removal, landscaping, whatever's needed to maintain the land. So that's the end of our presentation. Do you have any questions for us?
Okay, thank you very much for that presentation. Any questions or comments for the applicant?
Thank you, Mr. Sinclair. There was a photo that was an aerial that you showed us, and it looked like there were several cars parked along that roadway from that aerial shot. Were there cars there, and do you know who those cars belonged to?
There were.
There were our cars, our builders' cars, and
The realtor.
and the realtor, yes. Yeah.
So it's not-
He had a drone.
I understand
So
that.
we were there at the time.
Okay, so it wasn't other people that are using that for some other reason, that was all of your vehicles?
It's used a lot, but not at that point, yes. A lot of people access with ATVs and go back and illegally trespass on other people's property, but that was not the case in the photo.
Despite the signage that we have and the prior owners have had.
Thank you.
Additional questions for the applicant?
I don't think I have any.
Okay. I guess going through this, it seems as though, the most significant objection in addition to that of the delays was from the Perry Park Water and Sanitation District, from the correspondence that we received February 24th, 2021. It sounds like all of that has been resolved with them, correct?
Yes.
Okay, that's what we heard from staff. Could you remind me, Jeanette, how did Planning Commission come out on this?
This does not go to Planning Commission.
Never
This is a
went to Planning
replat, so it
Commission.
just
I
comes
was
to you.
searching through. Okay. So just coming to us, I don't have any additional comment. And with that, what I'll do is open it up for public comment at this time. Is there any public comment with regard to this item on our agenda? Yes, ma'am. Yep, come on up. And if you just want to state your name and address for the record, please.
Carolyn Jones, Jones, 7097 Perry Park Boulevard. My husband John and I have lived just north side of Ute Court for over 21 years. We owned the property 10 years prior to building our home there. And we fully support the replat right-of-way vacation submission of David and Julie to build their home at the end of what is now Ute Court. For some of the stated reasons, the driveway would be much less intrusive for us and much quieter than a public road. A secure driveway would stop the questionable traffic, heads back to Ute Court. Years ago, we asked the county to put that dead-end sign that showed up in David's pictures on top of the Ute Court sign because we had so much traffic coming back, but it didn't help. We've seen many cars, ATVs trespass on this property at the end of Ute Court. They go down there to party. I remember like one graduation night, we must have had like 10, 15 cars just ripping down there. They go down and play paintball. We found paintball evidence. There's been some dumping, and many vehicles come in the middle of the night and just sit there. So it's very weird, and we would be happy to see this end. We do meet our fire mitigation responsibility 2 times a year. We have large slash piles on Perry Park Boulevard. Our mitigation is mostly done from the Perry Park Boulevard side. And I'm certain if occasion occurs, we would be granted access to Ute Court for the tree slash removal that we need. David and Julie St. Clair contacted us before their right-of-way vacation application about their building plans and to get feedback and to hear any concerns that we might have. They have gone above and beyond with their communication to us. And we also got a February 5th of 2021 courtesy notification of application in process notice from Austin Brown, Douglas County Department of Community Development. Keeping out trespassers would be a huge benefit for our fire danger worries. We were evacuated during the Hayman fire, and when we see unauthorized people driving back into the woods and hanging out there, it's a big concern. We do support St. Clair's request for the replat approval to vacate undeveloped Ute Court public roadway and combine Lot 13 and allow construction of a private driveway to serve their future home on Lot 13. Thank you for your time, consideration.
Thank you, Ms. Jones. Further public comment?
Hello, thank you for being here today.
Hello.
My name is Sheridan DeLay.
Okay.
I'd like to first just point out the fact that when we originally moved into the spot, we had
And Ms. DeLay, if you could just state your address for the record,
So sorry,
please.
yes, it's 7139 Perry Park Boulevard, Larkspur, Colorado. So we had placed a trailer back on Ute Court that was in fact on our property. The police officers in that area immediately ticketed, and we immediately called them, let them know that it was on our property. We were just trying to keep it out of the visual sight of everybody else on said property. So I do in fact believe that they do a very good job as to making sure that there aren't riffraff going back there. And we agree with everyone here that we want to keep that. We moved our trailer. We were genuinely trying to keep it out of the vision of said neighbors. But that's just kind of a perception on that matter. Would you like to say anything before I speak on our behalf?
No, you go ahead.
With that being said, I would like to speak on the behalf of all of us. First and foremost, thank you for meeting us today on this very important matter regarding our family home at 7139 Perry Park Boulevard. Unfortunately, this hearing is due to an unfortunate series of events, those being no formal correspondence regarding the vacation of Ute Court, no in-person meeting regarding this matter and its severity to our property value. There are so many questions regarding the official protocol, i.e. how the neighbors were in fact notified and how did they give their written consent or verbal consent. Our property is totally unique in Perry Park with the rock formations and beauty of the land. It was lot 1 and picked by one of the developers of the personal property. Here are some considerations for this board. Ute Court provides the only flat property on our 5-acre site and the entire north side of our property. When purchasing this property, the Browns heirs told us that this particular lot could be subdivided. Of course, this made the property value higher in our negotiations. We as a family have discussed the subdivision. However, even if we do not subdivide, future property owners might. Not to mention that Sheridan, myself, would like to have this in the family for generations to come, Lord willing. As one can see, this vacate of the road would significantly improve the St. Clair property, giving the St. Clairs over 0.6 acres of land and diminish our property substantially. We never thought this county road could be vacated. Deforestation is a concern of ours as well. We need access to our land to deforest the lower portion of our property. The St. Clairs are now the property owners that back up to the National Forest. We are concerned with even vacating the road that other landowners in the future will not be good stewards of their properties. Our official notification was as follows. In May, when the St. Clair's builders came into Pegasus, he was rude to our daughter, stating that this road was a done deal. I was concerned that Sheridan was so upset, and I told her that we would have to be notified, first and foremost. In late May and early June, communication was made between Austin Brown, Douglas County's Department of Communication Development and Planning Services, and myself. He was well aware of how shocked I was to hear that the process was well underway, because we did not respond to a letter that we had no knowledge of. This process should have always been a certified letter, only to be considered by a signed document of all landowners that they give their approval to vacate the road. Oddly, no letter was sent to Perry Park Boulevard, or any in-person meeting was made between the St. Clairs and the delays. Being misinformed, Austin Brown first told me that our disapproval would now be considered and that the project would not just move ahead. It was later inferred by Austin Brown and Kevin Archer that the easement agreement was the way to proceed because the county would probably give the road to one person. We now know that that's not the case. This did not seem right on any level. If this was fair, then maybe the road should be vacated to the delays, and we would give the St. Clairs an easement agreement, since Ute Court runs along our entire north property. The St. Clair property alignment along Ute Court is minimal, and it begins at the very end of the cul-de-sac at the end of the road. I met with Kevin Archer and David St. Clair on Ute Court. Funny how perceptions are made. Thus, everything should be always in writing. Kevin Archer knew that I was trying to be neighborly. However, it seemed extremely one-sided. I was still not sure that this scenario with the county would play out in his favor. I was there as an observer of the St. Clair's intent and how this was presented for me for the first time, excuse me. I typed an email after meeting on the 28th stating that I was okay with the proposal with a signed legal easement agreement. The definition of a proposal is a plan or suggestion, especially a formal or written one, put forward for consideration or discussion by others. Obviously, I had my homework cut out for me. After discussions with others were made, it became very clear to me that I did not give my consent and that Sheridan and Chase would need to be in the conversation as property owners. It was extremely obvious that the legal counsel was needed. This was sent in prior texts and texts after we met at Ute Court. After going down the rabbit hole, Jeanette Barr as well as Kevin Archer have indicated that the road could possibly be split in half. This was valuable information that we should have been divulged in from the very beginning. Not to mention, Kevin spoke with John DeLay last week stating that a split agreement might be the best solution. I was corrected many times in this process when I said our road. But how can this be that it has just become to this, how can this be?
Ms. DeLay, I apologize. We normally only offer about a 3-minute
I
comment
understand.
period, so if you want to wrap up your comments and you can share
I'm very,
those.
very close. I apologize.
Okay, sure, please.
I'll just, okay, cool. It has been, regarding the easement agreement, we now understand how long the St. Clairs have been working towards an agreement on how to make this road his. However, it is unfair to put that all upon the delays. When we heard of this for the first time as a done deal, almost a year after they have stated that they had contact with us, we would like to ask you why it would be confirmed via, why wouldn't it can be confirmed via certified mail? It appears that the Perry Park Water took over 3 months to okay his plans. We also needed time to investigate our options, not to mention that many of these options have been oddly manipulated on the St. Clair's behalf. One major concern of ours is that he wants to put a gate inferring his ownership of our land. His version of an easement agreement stated we could only be down there for X amount of time. We want to be very clear. We would like access to our property 24/7, 365 days a year. And to give up that right would be unreasonable. Regarding the amenity clause and how it was initially approached on June 28th, we realized that it would be extremely hard to come to any agreements with the David St. Clair's assumed ownership of the entire road. The right to vacate would never have gone this far if we had not been misinformed. Here's the bottom line. We have one question. If the road in the beginning could have been split in two, which seems more than reasonable since since it is 50 feet wide with 10 feet easement on each side, we would encourage the commissioners that David St. Clair receive the north side of the road where they could put their 16-foot wide road and we will have the south side. We do not need an easement agreement because we will stay off his side of the road. We would love to consider his easement agreement at his official driveway going onto his property, which would help the St. Clair's not incur additional expenses moving the fire hydrant, etc. We would also think that the
Ms.
county
DeLay,
could
if you
help
could please
propose.
wrap up.
I promise you I'm on my last.
You're at
that's-
7.5
I promise you,
minutes.
I'm so sorry. We would also like to think that the county could help propose the situation in a timely manner. I'm sure Kevin Archer would assist all of us in splitting the road. John, Sheridan, and I have been in the service industry for years and look forward to a neighborly solution. That is all we are looking for. We hope that we can step back and have them put themselves in our shoes, for they would never consider giving up what they are asking for of us. I'm so
Thank
sorry
you,
for
Ms.
your time.
DeLay.
Thank
No,
you.
it's fine, and you guys are welcome to speak for 3 minutes as well,
No, it
apiece.
was on behalf of all three of us. Thank you, I'm sorry. No, we gave enough time. We're good. Thank you, guys. We appreciate it.
Okay, thank you. Is there any additional public comment on this matter before us today? Okay, seeing none in the room. Troy, do we have anyone online?
Thank you, Commissioner. I have no online comment.
Okay. And I want to thank the delays for being here. We just want to make sure that everyone has an equal amount of time to comment, and you're certainly welcome to comment at 3 minutes apiece if you need more additional time. Okay. Not seeing any desire for additional comment, I'll bring it back to the board for further discussion.
I'll go ahead and start. Well, now I suddenly feel bad for taunting staff to bring us a hard one, because obviously a hard one has come before us at this stage of the game. I guess the only problem goes back to my very first questions, because it seems to me, I'm sure we did hear from the neighbors around this proposed road that, it has been used as a road for years. And the only problem is that it seems that use was to access private property that those folks who made use of it didn't actually have the right to. And so I'm a little torn on this one, just because I can appreciate the perspectives that the delays have. But the St. Clairs have, probably through circumstance, been forced to go through a lengthy process by the county in order to have legal access to their property that would allow them to go ahead and build on the property, something that the neighbors currently do enjoy. So this is an odd one. And, you know, I'm very cognizant of the fact that we did hear from the neighbors speaking about not knowing that this could be a process that St. Clair's did engage in, that they could have had the opportunity to engage in as well, which is kind of a sad situation. At this stage of the game, though, I mean, I am inclined to support the applicants at this stage of the game, largely due to the fact that they've done the work, they've made acquisitions to the property, they've been forced to go through a lengthy governmental process to get us to this point. So at this stage, of course, being very open to hear from my colleagues, I'm inclined to support the applicant in this.
Commissioner Teal, and just really quickly, our normal process is following public comment to allow the applicant to respond to public comment. And I would just ask the board if they're interested in entertaining that, or if they would prefer to have additional discussion at this time.
Oh, I'd be happy to hear from the applicant if they'd like to make a further comment. Actually, you know, I would like to hear from the applicant because if for no other reason, Chair, and perhaps I misheard and omitted this, but I did not hear the applicants making commitment to either the 3 conditions or I think we heard them make a commitment to the 4th possible condition, but I did not hear them give assent to the first 3.
I would agree with that, and there may be some additional questions for the applicant as well. So if you want to approach the podium, a number of items were raised in public comment with regard to this application. So if you want to respond to those and then perhaps answer the questions raised by Commissioner Teal.
Okay. I have voicemail records showing on the date that I mentioned the phone calls to John DeLay in August of 2020 to notify the delays of the plan to do the right-of-way vacation, to apply for it.
Chris, are we on Exhibit 5 for today's hearing?
Yes, sir. Yes.
This will be 4?
As far as the question about the conditions, yes, we agree to those conditions.
Okay. Well, and maybe to help with some of our line of questioning, we heard about no formal correspondence or communications. I think you've attempted to address a little of that. I don't know if there's more you want to share on the correspondence end. You know, some comment around no meetings, diminished access and enjoyment of their property, issues associated with the deforestation and ability to address mitigation issues. Did you have any response to some of those comments?
Well, so I think part of the comments that we just heard, frustration of not being notified, aren't our responsibility or weren't because we didn't attempt that. But as I've shown, we did contact John, and I spoke with John, and he had no concerns. Why the rest of the family doesn't know that, I don't know. Why they didn't receive the letter, I also don't know, but we were at the Archer office when those letters were being prepared, and Julie did see all of those letters, and she remembers seeing the one that went to that was addressed to the delays, which is one of the exhibits in the official documentation from the county staff.
Okay.
It was addressed to a Castle Rock address that is the one that I believe is on the assessor's office, if you look at public records.
Okay, thank you, Mr. St. Clair. A question for staff. Any reason to believe that the delays were not communicated with as stated by the applicant?
I don't think so. I think there was a question about why don't we send, kind of registered mail or certified mail? And that's not what our regulations call for. Our regulations call for first-class mail. So our regulations were followed. That would be up to the board to decide to change those regs and make people go to the post office to pick up a piece of registered mail. But we do hear this occasionally, that notices were mailed out, but for one reason or another with the mail, maybe it didn't get delivered or it was delayed. I don't think we have any way of verifying whether, neighbors actually get the mailed envelope, but we do know that we mailed them out. We have a record of that.
Okay, well, as one commissioner, I think it's important to just confine, the decision-making to our current legal framework. And it sounds like, based upon your testimony, the rules and regulations associated with notice were provided. Okay, thank you. Any further questions or comments for the applicant?
Not for the applicant, no.
I don't think we addressed all of your questions. You asked about fire mitigation and access. So I just want to say the reason that we want a gate is primarily for me because my husband travels globally frequently, and you cannot see anything from where the house will be built. And for my own comfort, that's why I want a gate somewhere along there. And we just kind of wanted to make it less intrusive for the Joneses and the delays, so we thought moving it back. But as far as fire mitigation, we have a plan with Randy Johnson that we discussed. We've had an arborist out there. We've done fire mitigation. We've done mastication. And we have a plan to do more over the next 10 years. We were also evacuated during the Hayman Fire, and we have no desire to have anything happen to our property and we're between the National Forest and these properties. So any fire mitigation we do also benefits them, and any fire mitigation they do benefits us. So we would certainly grant access for that.
And we've had neighbors allow us to do fire mitigation for them. Last summer when we brought in the masticator, we talked with neighbors, it was the same period, and the ones that live up to the right gave us free rein to masticate in their property because all of the fires were burning last summer and everybody was more concerned and happy to have fuel removed.
And we're not trying to take anything away from them. We simply want to build our house, and this is how we were told to go about doing that. And we're going to have to pay to improve Ute Court, what is now Ute Court. We're going to have to pay to maintain it. And we will take that responsibility. And it's very long.
Okay, so let me make sure I understand this, and some more questions for staff and perhaps for legal. So my understanding is that based upon today's testimony, this is certainly a right that the applicant can apply for legally, correct?
Yes, this is, as I identified at the start of the hearing when I was covering notices, this is a replat, so it's subject to the replat process and approval criteria. Because the replat process is a subdivision process, the board is bound by a determination of whether it meets the criteria or not. If this was a zoning application, you would have a little bit more flexibility if we had anything pending that would change the outcome. But because it's a subdivision by statute, you are bound by whatever rules and regs the county has in place at the time of the application. So the primary question for the board is, does it meet the approval criteria or not? And while I've said this to the board before, this is probably more for the audience. If the application meets all of the approval criteria, whether you like the application or not, you must approve it as a matter of law. If it fails to even meet one of the approval criteria, and again, whether you like the application or not, you must deny the application. So the question before you is, for this replat, does it meet the approval criteria or not? Now, when it comes to, so do they have a right to apply for it? Absolutely, they can apply for the subdivision process known as a replat and bring that to a final decision in some form. With road vacations, which is also somewhat what this is, although it's more of a replat under our regs, the board has really unlimited discretion how to assign ownership of right-of-way that's being vacated. It could be vacated in whole or in part. It could be assigned various different interests. You would certainly need to reserve any rights for utilities or anything that has used the right-of-way prior to the vacation. So there's additional factors you could consider. Not that long ago, probably 8 or 9 years ago, the law was if you vacated right-of-way, you would assign it in equal parts down the center line to abutting property owners. But that statute was changed to give the board more discretion as to ultimate ownership. And so it is consistent with what's being requested by these applicants. Doesn't mean you're bound to do it, but you are bound by the approval criteria. So does that help, or does that generate more questions than it was worth?
No, I think that's helpful, and I think Commissioner Teal was accurate in stating that this is a challenging one. And, I think in Colorado, in the West, and certainly in Douglas County, so much is resolved when neighbors are neighborly and things are worked out among those that are adjacent to one another. And it sounds as though best efforts were entertained or at least attempted, and some question of fact on that, I understand. But because communications have devolved, no doubt that's why you're before us today. Although you would be anyway, certainly it makes it much more difficult when there's confusion and disagreement among the parties. So what I might do, because this is challenging, I think we need to refer to our application and go back to the legal criteria in the packet on page 9 and walk through the legal criteria for approving this replat. In 70401, it talks about complying with all applicable standards. Staff comment is that the replat is in compliance with all applicable standards. 70402 does not create non-conforming lots. The staff comment is that no new lots are created. 70403 complies with this resolution. The staff comment is that the replat is in compliance with all applicable sections of the DCSR. 70404 conforms with the goals and policies of the master plan. Again, it says the lot is located within Perry Park Water and Sand and will support that entity through tap fees and service charges. 70405 addresses the design elements established in Article 4, Section 404. The staff indicates the boundaries of the lot are intended for residential development are unchanged, and that the additional flag captures the vacated public road and will be used to construct a private driveway, and that no other design changes are proposed. 70406 conforms with Section 18A water supply. Because Perry Park Water and Sand will continue to provide service, there's no change in water demand or supply associated with this request. With 07 provides for a public wastewater collection and treatment system, and if other methods of wastewater collection are proposed, those will comply with state and local laws. Staff comment, there's no change in sewer service associated with this request. 08 identifies all areas within a subdivision which may involve soil or topographical conditions. Staff comment is a geotechnical study was not required for the replat request. And then the final few here provides adequate drainage improvements. Drainage is going to be addressed through the desk permit process at the time of building permit request. 10, transportation improvements. No new lots are established within the replat. So construction of a public road within the right-of-way is not necessary. And then the final two, 11, protects significant cultural, archaeological, natural, historic resources. Staff comment, none known to them with regard to cultural, archaeological, or historical resources on this site. And then finally, with 12, has available all necessary services, including fire and police protection, rec, utility services, streets, and open space. And then the staff comment is that all necessary services are available to the site. So, based on that review, and thanks for, indulging a more granular look at this, it appears to me as though all of the legal criteria under the approval standards have been met. I know that staff has proposed a potential condition 4, which may on some level assuage the process and allow for things to move forward a little more smoothly, but perhaps it'd be appropriate to ask the applicant if you would be comfortable with condition 4.
Yes.
Yes.
Okay. Jeanette, is there more? There's probably more comment. Yep, go ahead.
Yeah, if you don't mind, I'd like First of all, I'd just like to say that there were 3 delays standing here, and if they'd each gotten 3 minutes, that would have been 9 minutes. So, I don't know if it's appropriate to ask if there's anything else they wanted to say that they didn't have the opportunity to say. Because you said they had 7 minutes, that Sheridan had used 7 minutes, so they should have had 9 minutes. So I just want to make sure that we hear from everybody. And then I do have some additional questions for staff.
Yes, and I would agree with that. I emphasized that a couple of times. You're welcome to a full 9 minutes, however you would like to divide that up. So yes, Mr. DeLay, if you'd like to come up and share a little bit more, please.
John DeLay, 419 Lewis Street, Castle Rock, where the letter supposedly was sent to. Mr. St. Clair and I had a conversation. I've never seen him before today. Never seen him face to face, and that's kind of unusual. A guy who has a restaurant for 32 years in Castle Rock. I look forward to getting to know him and getting to know him better in a good way, positive way, a neighborly way. When Kevin and I had our meeting last week, and I've known Kevin all these years I've been here, he suggested, and I agree with him, why can't we divide the road in half? They can pave their side, we can grade our side, they can have the utilities go up their side, because their property, it was on the map earlier, is V-shaped like this, and Ute Court comes up to the very beginning of their property. The county owns the rest of the road. Why should they be given all that land 100%, and that's what they're asking for? Why can't we cut it in half? And I got one tough question for the St. Clairs. How many trees did you already cut on our property? I know the answer. And that in itself is illegal. And big trees, guys, were cut. Thank you.
Thank you, Mr. DeLay. And is there anyone else? Yes, Ms. DeLay.
I'm sorry, this is somewhat emotional. My name is Janie DeLay, 419 Lewis Street. First and foremost, I can assure you, we received nothing by mail. You're talking about our property, our rights, our daughter's rights in the future. Hopefully, she will be on that property long after myself and John and the St. Clairs are gone. This deforestation is a huge issue on this property. The property is, I wish you could see the topography. It is, the house sits way up on a hill. There is no way for us to get down to our property to properly mitigate.
Mr. St. Clair said it for us. Mr. St. Clair, when we had the map up on the sheet, it had a ton of rocky terrain, and he said for us how it was all mountainous terrain, very steep. The problem being is that we're giving up the rights to the lower part. We have no access to get to the lower part of our property due to how our property is set up. And so our concerns from the beginning, my parents always wanted to be neighborly and maybe have these little conversations that might have been had, but the fact that it was never put into writing as to what we were given up is how we're a little confused on how it would be legal until this day and age, until today, how it would be legal considering how much we are giving up. We are asking nothing of them. They don't need to give anything up. What we give up in today and why we are here and why we are obviously a little worried about this matter is because we don't really know what this means in the future. The easement agreement that he sent forth to us, the actual agreement in writing, the only one we ever received, adds some questionable verbiage as to what we were given up and whether we would even be allowed to be on our property more than X amount of time.
I think like we stated, the bottom line is, please, for the love of God, I feel like everything in our world that's right is now wrong, and everything that's wrong is now right. We should have access to our property. It's too long a road. It's totally unconceivable to me that this would, that you could, that this could even pass. I just, and you have to remember too, I myself started this process in June. There have been other issues on my plate, but I did the best I could, and I never, from day one, Kevin Archer, David St. Clair, they both knew that this was a huge issue for us.
And we want them to have a gate. We don't want anyone going back on Ute Court either. We want the same things. I think that's why I frazzled myself, but started with what I did on the matter. From what I have perceived living there, they have always been right on it to get anybody off that road. And we agree to that. We want her to feel safe. We want them to have a gate. Our confusion as to how it's possible to give them the entire thing, seeing where their property line starts. And we were always willing to work with that. But we haven't tried to prolong it in a way that they can't make this happen or have their home. We can't just verbally agree on, in a slight manner, on what we're giving up. This always had to be put into writing as to what we are agreeing to on both sides and both parties.
Oh, and there's one more
And I'll just say
very
you're at
important matter.
3.5 minutes, so if you could just wrap
Okay,
up, I
this will be
appreciate it.
quick.
Yep.
There's one more very important matter. If they did their due diligence, they would know that on the deed is my name, my daughter's name, and my son's name. This is a property that is owned, that came from my family, and I know that John was being neighborly. I mean, you can call John back up here again. Again, this needs to be in writing.
Yeah, it being
So,
stated
anyway.
on that paper that they
That's all.
talked to John
Thank
was
you
just
for listening.
confusing for us, because he was just having a conversation with someone that gave him a call.
Okay.
Thank you, guys. Thank you for your
Thank
time.
you
We
very
apologize
much.
for any
May I
extra
continue my time?
Sure.
So, Mr. Ingalls, if you could tell us what other options we have. We can approve or deny, but I think there are some others. And I am looking at an email that is dated September 9th by Janie DeLay that says, "I never would have wasted any time in any other direction if she had known that the road could be split in half." So we've got the parties both here. They're both talking to us. I'm wondering if we could do a continuance until October 12th, the date certain, so that both sides know that that is when they have to have a decision made to come before us. And I'm not trying to prolong anything for anybody that's already spent a lot of time. But this is a decision that we're going to make that's going to impact this neighborhood forever. And if there's a way for something to be resolved peacefully that does not create we also have other neighbors here. So if we can get the neighbors to talk with each other and come back to a solution by October 12th or a different date, if that's what they want, if both sides will agree to talk with each other and get something resolved, is that an option on the table before us?
It is an option. Ultimately, the applicant somewhat controls the conversation regarding that. They've got an application pending, and they've asked for this hearing today. If they're agreeable to a continuance to try and work out some details of a compromise, there's nothing prohibiting the board from doing that. So that is an option. If the parties believe, if the applicant believes that that's worth pursuing, they can certainly agree to it, ask for it, et cetera. I don't think the board can necessarily dictate to the applicant a solution if the board believes that the approval criteria are otherwise met. If the board's struggling to conclude the approval criteria are met, a little more time for deliberation or for the parties to talk may well make sense. So it depends on the reason for the continuance. Is it a need of the board, or is it something for the benefit or potential benefit of the applicants? But at the end of the day, if asked, the board will have to weigh in on the approval criteria. Does that help? Enough?
Yeah, I just think that sometimes there's the legal black and white, and sometimes there's a bigger item that needs to be considered, and neighborhood unity is something that if we can get everybody to agree to get something resolved, I think that is well worth the extra time.
So we're going a little bit out of order. We did have some additional public comment, and so I want to make sure that the applicant addresses those issues that were raised if there's interest in doing that. So I would ask the applicant, the St. John's, if in the additional public testimony, if there was anything that you heard that you would want to respond to.
Actually, may I ask a question before we kick it back to the applicant?
Sure.
I'd like to, can I please have the slides display the Fourth Amendment? Okay. So I've been doing land use for 7 years now, and I've been pretty patient coming up to the county in terms of what we do with these amendments. And I guess this is a really good time for me to ask, what is the point of this amendment?
The point of this amendment was to try to capture on the record a commitment that the applicant made as part of their PowerPoint. They sent me their PowerPoint earlier today where they were going to make a commitment on the record that they would provide access for, wildfire mitigation and for parking. And so this was a way of, rather than just have it be on the record, which is still a commitment that they're bound to somehow get that on the plat itself so that it would, apply to all the successors and assigns of Lot 12, and so that there would be some basis for it. So that is where this came from. It is an option. It's a way of capturing their commitment.
You just said the exact words were, which is a commitment they are bound to. How? How are they bound?
It's by, wrong one. Well, they're bound by condition number 3. Because they have come before you in a hearing and they've made this commitment on the record.
Yeah, but what does that commitment mean? Because, I'm still the new guy here. I'm not used to dealing with commitments when we talk land use hearings down the street in Wilcox Building for the last 7 years. So this is something that's been new to me, and, every applicant seems to come forward and say, yes, they agree to these conditions. What does that really mean? What is that commitment? What is the consequence of violating one of these conditions?
Well, I'll let Lance speak to that, but there's sort of, when somebody makes a commitment like this on the record up here before you, we tend to because those things can be maybe forgotten, or you've got to go back and listen to the audio. So if there is a commitment like this that somebody gets up and says, that's why we as staff like to get that captured in writing.
Okay, it's really important for me to get a good answer on this right now, because every land use meeting, we are seeing verbiage like this used. Mm-hmm. We are seeing amendments like this used. And it's often with a crowd of people that are really upset because a multimillionaire is coming in to build houses and burn up water that's in this county. So it's really important for me to understand right now exactly what these mean when we burn up public time and ask for somebody to make these commitments. Because if I'm hearing that it's a really good idea and it's something nice to be said, I don't know. We might be talking about making use of amendments like this. Now, if it's a commitment that has actual consequences when violated, well, I'd kind of like to know that, particularly in this instance.
Let me take a stab at addressing that, because condition 3 was a dictate of a previous board, and there were specific reasons for the condition being added to every land use application, but it has to do primarily with enforceability. So historically, just so you know, it goes back to the Sedalia landfill. And the Sedalia landfill was a very interesting applicant. They made numerous promises on the record, water commitments and commitments to the community and commitments to this and that. And at the end of the day, they didn't do a lot of it. They did a little bit, didn't do a lot of it, didn't even have the water to dedicate for one of the commitments. It was just a bunch of promises on the record. And it angered the board at the time, because what happens following hearings is the public comes back to the board and says, look, this was your approval, these were commitments made to you, and now we want you to enforce it. And with that application, there was no specific way to enforce it. So again, that board, and it was probably led by Commissioner Boand at the time, wanted language like this and wanted language like this for every application that comes forward in the future, so that if an applicant stands before you and makes a promise, if you approve my application, I will do X. He and that board wanted some enforceability of that promise, and not just enforceability generally, but enforceability by the county. So that's the reason for condition 3. The reason for condition 4, to add it as a plat note, would to be to secure the interest. So if there's an interest being given to the delays and it appears on a plat note, it's probably not only enforceable by the county, but enforceable by the delays. And so it's reducing a land use interest to writing so that in the future, people that may not even be in front of any of us today know what that means, know what their rights or obligations are, and it's therefore usable. It's something that means something beyond today's hearing. So that's kind of the history of condition 3, and the reason for condition 4 is frankly because I said, look, if there's going to be a commitment made, Jeanette, please do reduce it to writing so people know what it is, and a plat note is probably the single best way to secure a land use right, because if it's not in writing in Colorado, and if it's not recorded in Colorado, it's probably not a real estate interest at all.
All right, with that said, can we please go back to amendment number 4? Chair, it would be of interest to me that after that knowledge was conveyed by the county attorney, it would be of interest to me to ask the St. Clairs to once again commit to amendment number 4.
Thank you, Commissioner Teal, and thank you, Mr. Ingalls and staff, for walking us through that process. I think that's a benefit to us as a board and certainly for the listening public. I believe we did hear a commitment from the St. Clairs on condition number 4, but to the extent it would help Commissioner Teal, I'm happy to, why don't you come up and you can address some of the additional public comment and then just reiterate your commitment on number 4. So again, just to be clear for the record, for the St. Clairs, do you agree to condition number 4 from the staff assessment?
I do.
Okay, yes. Thank you. And my understanding is that that is really a concession to the delays and others that would hopefully provide for that inclement weather, parking, deal with landscape activities, wildfire mitigation. And so hopefully that addresses some of the concerns that were raised today. But in terms of the additional public comment that we heard at the end, did you have any response to that or did you want to add anything?
Did you want to? Okay, so it was inferred or it was communicated that we didn't reach out to them to discuss this. There certainly was a period between the conversation with John and when we found out, all of a sudden there was a problem that we weren't aware of. Once we were aware of the problem, then we went through repeated attempts of communication, some of which were successful, many of which were not, unfortunately. So we didn't want it to be set that we were not attempting to work with our neighbors, which of course we were. There was a comment about the continuance. The concern that that would have to us is that given the site that we have for a build site, winter shade comes in quickly. Our builder is concerned and wants to break ground quickly. If we delay this one more month, then it's right on the edge of whether or not he would be willing to go forward, and we would lose another full winter before we could actually break ground again. So that's a big concern for us.
Okay, thank you for that. So I think I've heard from both of my fellow commissioners, and I would just add that, limiting my scope objectively to the legal framework and consistent with council's advice, 100% of the legal approval criteria have been met. Therefore, we have an obligation as a board to approve this today. But what Commissioner Thomas references, I believe, is accurate. That, sometimes just because you can doesn't mean you should. I think it would behoove you and benefit you to have a conversation with your neighbors in the Douglas County way. You don't have to, and I'm not trying to persuade you either way. I'm just simply referencing the fact that I think it would help. You're certainly within your rights today to demand as the applicant that we enter a decision today. It was raised by Commissioner Thomas, a suggestion that you continue today's deliberations so that you can have a productive conversation with your neighbors. And so I would just raise that with you now as an option to pursue. It's certainly well within your decision-making whether or not to do that.
We would love to have conversations with them, but that has not happened. I can't tell you how many times emails have gone unanswered, telephone calls have not been answered, voicemail is full, nothing. We can't delay anymore.
You reached out to Sheridan.
I reached out to the daughter as well and wanted to set up a meeting to meet who actually lives there, who will be our neighbor. And she said, yes, please text me later in the week and let's figure it out. I know she's busy. We're also very busy. We don't run a restaurant. He runs a company. I'm a controller for a $300 million company. We are very busy as well. I would love to have had time, and I get no response at all.
Ma'am, we're going to keep it in order, okay? So our next hearing will be September 24th. And what I'm hearing you say today is, I'm sorry, is there?
28th.
Oh, the 28th, okay. It's okay. So September 28th will be our next land use hearing. I'm hearing you say that you've made many attempts to have a conversation. I will again suggest the opportunity to continue this conversation today to September 28th, which is only a few weeks away, so that you can enter into a productive, hopefully beneficial conversation with your neighbors. Like I said, you don't have to, and if you tell me today enough's enough, we want to move forward, that's well within your right to do that. Since you will be living next to these individuals for a very long time, again, I might recommend that you take us up on the opportunity to have that as a condition and simply have that conversation with your neighbors. But I'll leave that to you, Commissioner Teal.
Wait a minute. I mean, hang on. We've just heard of the binding here on condition number 4. Condition number 4, unless something new is going to be added, meets the concerns of the delays. It addresses the concerns of the neighbors. Well, the answer is no, but then why didn't we hear about that in your written testimony that you read? I mean, there must be an element of common sense that is, and fairness that's introduced here. These people have been going through a very long process. You guys have been apprised of the process and you've had an opportunity to participate. There must be a degree of fairness and common sense applied. If there were other conditions that should be addressed here in number 4, a little communication obviously could have gone a long way to get us here. However, from what I heard, what we see written in condition number 4 here does address your concerns, guys. You too understand that this is a commitment that you will be held to, that it will be a plat note, it will be attached to the record. Future owners of filing number 1 will be able to see this at the time of their closing. They will be able to research this, and you guys are willing to live by this commitment.
Yes.
To my colleagues, I do not see a need for a continuation.
Commissioner Thomas?
I'd be interested in the applicant's answer to your question.
Okay, well, I certainly would agree with Commissioner Teal. I mean, it seems obvious that you have been delayed. That seems to be the word du jour today. But, and again, I would just restate that clearly from a strictly legal perspective, we had the obligation to approve your application today. So again, I'll render that question to you pursuant to Commissioner Thomas's question. Are you interested in a continuance?
Can we confer for a moment?
Certainly.
I haven't liked conditions at all. But that's me. I'm the new guy.
No condition zoning at all.
Okay.
Either have your old zoning or your new zoning.
So we would not like the continuance. We would like to work with the delays to see if there are ways that we can mitigate concerns more. But 13 months is too long. We have to get moving.
Okay.
It's been emotional for them, it's been emotional for us.
Sure, I understand. Well, thank you for that. And with that, I will bring it back to the board for further discussion and or a motion.
Can I ask for clarification before you vote?
Sure.
It sounds like there might be further discussion on this plat note. Would staff be in a position to accept changes to the plat note if you were to approve this application with condition 4? Let's say, for example, they agreed on a little bit more to the plat note. Would staff be in a position to accept that without coming back to the board?
I would be okay with that.
Thank you.
Thank you for that clarification, Mr. Engels. So then again, I will bring it back to the board for a motion and or further discussion.
Chair, if it pleases the board, I'd like to make a motion to approve the Prairie Park filing number 1, 13th Amendment replat with 4 conditions as presented, project file SB 2020-062.
Second.
There's a first and second on the floor. Is there any further discussion? Seeing none, all those in favor signal by saying aye.
Aye.
Aye. And that motion carries. Thank you very much. And with that, we are adjourned for our land use meeting for today. Thank you for being with us.